To begin, I'd like to introduce you to Matthew Fletcher. Does your hand go high? Head of litigation at Gosschalks. Matthew specialises in resolving disputes in the construction and property sectors. He acts for a number of the leading construction development companies in the Yorkshire region and regularly deals with adjudications, arbitrations, TCC litigation and representing parties in mediations. Matthew has been involved with construction excellence for many years now with his team, who he will introduce you to, and he regularly delivers specialist construction seminars across the region. So I'm just going to hand straight over to Matthew and go on to mute.
That's brilliant. Thanks very much, Tom, and good morning, everybody. Thanks very much for joining the first virtual version of our Gosschalks Construction Excellence seminar. We're going to be trying to be quite informal this morning. We've sort of put together a discussion panel with some of our lawyers to look at the topics we're going to go through. So just to introduce everybody, firstly, we've got Will Buckingham, who's a partner in our construction team.
Morning.
We've also got Abigail Milner, who's also a partner in our construction team.
Morning.
We've got a special guest today, Steve Dillon, who's actually an insolvency specialist lawyer and heads up the insolvency team at Gosschalks.
Odd one out today. Morning, everyone.
That's great. So what we're looking at today is managing insolvency and payment risks in the construction industry. So these risks can go both upstream and downstream. If you're the employer, you have the risk that your main contractor might go bust halfway through a project. If you're the main contractor, you have the risk that one, or even worse, more than one of your subcontractors might go bust during the project. But you also have potential upstream risk as well, because it's not unheard of for employers sometimes to go bust. It's perhaps slightly less usual for that to happen. But particularly in a recessionary environment, if you're dealing with a high risk project like a retail or a commercial development, it's not completely unheard of for the employer to go bust, and obviously that causes major problems for the main contractor if that should happen. So how serious are these risks at the moment? Well, the good news is that contrary to our expectations, 2020 was actually a very strong year for the construction industry. In many senses, insolvencies were actually down by 40%, which obviously was fantastic news for the industry. However, I think we just need to be careful about sort of getting into a false sense of security there, because the government did spend £20 billion or thereabouts on the industry in terms of furlough payments, government loans, deferring the VAT and other tax payments. And I suppose realistically, sooner or later, that life support machine is going to get turned off. We also have the potential risk for inflation going up, which may lead to increases in interest rates, which again may affect the economy generally and also the construction industry. So it is possible that things could turn ugly. Hopefully that won't happen, but we need to be prepared for that risk. I suppose just to ask you, Steve, from your perspective as an insolvency lawyer, obviously you were probably a little bit disappointed that things were quieter than expected last year. But what's the outlook from the sort of the insolvency professionals world at the moment?
You make me sound like a mercenary, Matthew. In fairness, we are still expecting a glut of insolvencies. The question really is when. The reason why we're expecting that, you've already touched on. Many businesses have taken business bounce back loans and coronavirus business loans in desperation and are now finding it a struggle to comply with their loan covenants, creating obvious risk that they'll be called in. Many have also deferred VAT liabilities. That period currently ends in June, the deferral period, so that might well have an impact as well. And the various temporary legal protections against creditor actions, in particular against preventing creditors winding up petitions and actions for rent by landlords, were brought in by pandemic legislation. But they are currently due to end over the course of the next month to 6 weeks. They have continually been extended throughout this pandemic period, so they may well be extended again. And I'm sure if they are, they'll be extended at very short notice, so will everybody be hopping around. But for all of these reasons, the need to find ways to ensure projects continue to run smoothly is becoming even more relevant.
That's very interesting. So obviously we haven't got a crystal ball. We don't know for certain what's going to happen. But I think the message of the seminar this morning will be it's better to be safe than sorry. Now is the time to get your house in order before we potentially do hit more difficult times. So we're going to be looking at some of the safeguards that you can put in place to protect yourself against insolvency and payment risk. And we're going to be looking at that from the perspective of what you do when you enter into the contract, what things you can put into your contract at the beginning to protect yourself. But also we'll be looking at it from the perspective of once you're running the contract, what steps can you take to protect yourself, particularly in the sort of the arena of administering payment applications. There's a lot you can do there to avoid getting caught out. We've organised the seminar around sort of 5 key questions that we're going to go through. So I've just got to put up question 1 now, I think, if that's okay, Steve. Excellent. So the first question we're going to look at is how do you avoid becoming the victim of a smash and grab by your contractor or subcontractor? Now, this is the really big issue at the moment. I mean, it's amazing just how many instructions we get on behalf of people who've potentially become a victim of this, and also acting on behalf of people who want to pursue smash and grab claims. It really is coming up all of the time, and it is very much linked to the issue of insolvency as well, because if you get caught by a smash and grab and have to pay money out, the danger is that the company you pay that money to will then go bust and you won't be able to get that money back again. So I'm just going to have a quick refresher as to what we mean by smash and grab. So most contracts allow the contractor to make an application for payment. So in this example here, let's say the contractor wants to make an application for £1 million. However, the employer does not think that he's entitled to £1 million. Maybe there's been all sorts of problems on this project, and the employer actually thinks that his works are only worth £1. So having received that application for payment, what does the employer need to do? The first thing you can do is issue a payment notice. It's required to issue a payment notice, and it can issue that specifying £1 as its valuation of the works. If it does that, it's fine. On the final date for payment, the sum payable is £1, so everything is good. However, if he takes his eye off the ball and doesn't serve a payment notice, he has another bite at the cherry. He can serve a pay less notice, again valuing the works at £1. And if he does that, all he is required to pay is £1. The problem comes, however, if something goes wrong and he doesn't serve either notice or he serves them late. In that scenario, where the contractor has applied for payment, the sum payable then becomes £1 million, and the contractor can start a smash and grab adjudication, or possibly go straight to the court and bring a claim for that £1 million. And it doesn't really matter however strong the employer's arguments are as to why he's not entitled to £1 million. It doesn't matter. It's a paper exercise. It's a cash flow exercise under the Construction Act, and on an interim basis, the employer has to pay that £1 million over. Now, once he's paid that amount of money, he can then potentially and usually start a true value adjudication to get the works properly assessed, and hopefully get an order from an adjudicator to have the monies, all or at least some of the monies, paid back to him. But the difficulty is once you've handed the cash over, there are no guarantees in life. Perhaps this contractor was on the rocks already and then goes bust for other reasons. Even worse, perhaps that contractor uses some potentially dubious tricks to try and get the money out of his company into another company, or pay off other creditors first. Potentially you can unravel all of that later on through the insolvency procedures, but there's no guarantees of that. So once you've handed over the money, you really are at risk that you won't get that money back again. So this is a really serious thing, and we just need to look now at how you can avoid becoming the victim of a smash and grab.
Yeah, it's a very good question, Matthew. It's one that we are getting asked quite a lot because of the popularity of these smash and grab claims. Just to sort of give some numbers and put it into context, we would normally see something maybe 2 or 3 of these types of claims a year. whereas this year alone we've had sort of 4 in 4 months. So they're quite a hot topic. How do you avoid becoming victim of one? Well, I suppose working off what you said, notices are extremely important. It's really important to make sure that you get a valid notice served. What do we mean by a valid notice? Well, obviously it needs to comply with the terms of the contract. It needs to be served on time at the right place. It needs to be clear and it needs to be unambiguous. All of that, I suppose, to an extent, might sound like it's common sense, but we are still seeing these problems arising. There's a multitude of different reasons why a notice might not be served, or a proper notice might not be served. Sometimes we find people are sort of carrying on serving the notices they've served in the past, presuming they're okay when really they're not. Other times we find that issues might have been caused by things like furlough, and the people that might usually have dealt with it was away from the office. Unfortunately, the Construction Act doesn't have a caveat in it, which means that the law doesn't apply because furloughs come in. So it's really important to make sure that people have robust systems in place to make sure that when notices come in, they are properly dealt with. And on top of that, we'd always say that if you receive something that looks like a notice from a subcontractor or whatever it is, it's really important to make sure that you serve a notice in response. Even if it might not be valid, you can always reserve your position and serve it without prejudice to any of the points that are in place. But at least if you've put some sort of notice out there, it really reduces the risk of any smash and grab claim being brought.
Yeah, there are also certain things that you can do when you come to draft your contract to try and prevent you, again, becoming a victim of a smash and grab adjudication. You can amend your contract so that any of your subcontracts to extend the deadline for you having to give a pay less notice, to give you as much time as possible to correctly administer the payment terms you've got. The Construction Act does allow you to agree the timescale between your due date and the final date for payment. So if, for example, you're working under a JCT contract, under the standard form, you've normally got about 5 days before the final date for payment to serve your pay less notice. But if you extend that to 1 day, it then maximises the time available to you. And then you can also extend the period between the due date and your final date for payment, giving you as much time as possible to hopefully avoid getting caught out by those deadlines. Another thing you can do when drafting your contracts is to stipulate that the applications for payment must be sent to a designated person at a particular email address or postal address who can then process them. By having that one point of contact of who you know is going to pick them up, it reduces the risk of someone overlooking those important payment documents. Just as a side point, be aware that the most recent case law does suggest that you can't link the receipt of an invoice from the payee to your final date for payment. Now, most payers want to make sure that they do receive a valid VAT invoice for the amount that they're going to have to pay out, and the parties normally try and allow for this by linking receipt of that invoice to getting paid and that final date for payment. But like I've just said, you can't do that. What you can do instead is include a separate contractual obligation for the payee to submit that VAT invoice. Just don't link it to the deadline for payment. It's also worth checking that any of your subcontracts don't have more generous provisions for payment than you've got in your own contract, because otherwise you could end up having to pay out your subbies before you've been paid yourself. Again, that sounds like common sense, but I do come across this in people's subcontracts, leaving them exposed.
You're just linking into that. We do find people talk about having payment schedules in their contracts in terms of when applications for payment need to be made, when the due date is, when the final date for payment is, that sort of thing. They're quite good to have. We certainly wouldn't say against it. It gives everyone a degree of certainty in terms of when things need serving. You don't have to start working out on bank holidays and all that type of stuff. So they're really useful in that respect. What we would say, though, is that you need to make sure that if you've got a schedule like that, it needs to factor in the potential that the project could overrun or go on longer than expected, and you need to make sure that's factored in, be it through either having a very, very long schedule or having some kind of mechanism in the contract for it to continue thereafter. Obviously, also on top of that, if you've got your dates and they're all specified, you need to make sure you comply with them, because it becomes a lot harder to try and argue that someone served a late notice when you've got specific dates listed in the contract that have then been hit.
I think it's really important, whatever you're using in your contract, or if you have got a payment schedule, to make sure that you stick to it. If you're the employer and you're administering the contract, when people start allowing applications to be made late, you then get into all sorts of issues as to, does that then extend the deadline to serve the payment notice or the pay less notice? And that sort of confusion is the recipe for a crafty contractor to try and put in a smash and grab claim. So stick to whatever you've agreed, and keep the contractor sticking to that as well. And just generally speaking, just to reiterate, always be vigilant. Whenever you get anything that looks like an application for payment or a proposed final account, whatever it is, think very carefully. Do I need to be serving a notice? When do I need to be doing it by? How do I need to do it? I mean, even under a sort of informal arrangements with subcontractors, it may be they stick an invoice in. That potentially is enough to trigger the process to be treated as an application for payments, and then potentially becomes a trap for you. So every document you get in is a potential trap, and you've got to be alive to that, and make sure all of your staff are alive to that risk as well. So we've obviously looked at the danger of getting caught out by a smash and grab. I suppose the next question we want to look at is, what can you do? Is there any way of fighting this if you get into this situation?
Yes, I suppose that's the nightmare scenario. Is you suddenly, Christmas Eve, whenever it is, you suddenly find that a notice of adjudication lands on your desk, and you've suddenly been told that you failed to serve a payment notice or a pay less notice. So in the example we gave, suddenly there's some subcontractor saying that you owe them £1 million. I think, Matthew, you've dealt with both the most recent one of these. So do you want to kick us off in terms of the things that you look for in trying to defend a claim?
Yeah, I mean, so this is happening all the time. You get a telephone call from a client. As you say, they've received a notice of adjudication. Suddenly they're being told that they've got to pay out all this money they don't want to pay out. So the question that we have to answer is, what can they do? Is there any way of defending a smash and grab adjudication? And there may be ways out of it. The first thing to look for is whether or not the application for payment was actually valid, because you can't do a smash and grab unless the contractor has made a valid application for payment. So did it comply with the contract? Did it contain the information that the contract says it must contain? Did the application get sent to the right person? Was it sent at the right time? Does it refer to the correct due date? If we can find a defect in the application, then potentially we can defend the claim on the basis that no valid application was made. The courts have also emphasised that there's got to be clarity in terms of what the contractor's doing. So if they act in a sort of a way which is confusing, and there's any sort of ambiguity in their paperwork, that potentially then gives you a defence to the claim. So look for that. If it's not clear what they're up to or what they're doing, that might be a way of escaping liability. And whilst the courts have been quite firm in saying that the whole purpose of the Construction Act procedure is that whatever you ask for is what you get if there's no valid notice, there is a potential chink in that the courts have said that if there's an element of fraud in there, that would then prevent a contractor from running a smash and grab claim. So look carefully at what they've applied for. You potentially can run the argument in adjudication that the application is fraudulent where the contractor is asking for monies that clearly are not due. Perhaps they've asked for monies for works that just haven't been done. Whether or not that's enough to win the adjudication is a bit of a moot point, but it's potentially worth worth arguing if you can convince the adjudicator that fraud is going on here. Any tainting of the application by fraud will potentially give you a defence. Now, if the client has served a payment notice or a pay less notice, but they've done it late, the other thing we potentially can try and rely on is the argument of waiver. So I had a situation recently where my client came to me with the problem that they'd served their payment notice late. However, having served that notice, the contractor then put in a VAT invoice for the amount they'd put in their payment notice, thinking, right, that's our normal process, we'll stick that in. So rather than invoicing for the amount they claimed in their application, they actually invoiced for the amount in the late payment notice. They then realised they could potentially pull the smash and grab trick, but then we could argue actually that they'd waived their rights because they'd issued that invoice in line with the payment notice, and therefore they'd waived their entitlement to go for a smash and grab. And in that case, it was many millions of pounds that the client didn't have to pay out as a result of us being able to run that defence. So it's not necessarily the end of the world. If someone tries on the smash and grab, you may have a potential defence, but you've got to act really quickly. You know, if they're starting an adjudication, you've got to get advice straight away to look at the potential options you've got. So let's say you can't do that. Let's say you've lost the adjudication and the adjudicator has awarded monies on a smash and grab basis. Will's now going to look at what other options you've potentially got in that scenario.
Yeah, I mean, the usual premise is that if you've got a valid adjudicator's decision, the court will look to enforce that. What the courts and the Construction Act have said is that adjudication is a way of resolving disputes. If people are simply going to ignore an adjudicator's decision, then it avoids the whole point of having adjudication in the first place. So they want to make sure that adjudicators have got some teeth. That being said, an adjudicator's decision is always reviewable by the court. They're seen as being sort of, if you like, a way of getting a dispute resolved quickly, but it might not always be the correct decision. So the court wants to have that ability to look at the decision, decide if it's wrong, to rectify that. Now, what a court doesn't want is a situation whereby the first adjudicator's decision resulted in money having been paid across to a receiving party. If the court then looks at that decision, decides the decision is wrong, that the money can't go back to where it should be because that receiving party has had some kind of liquidity problems and is in a distressed state. So in that scenario, where there's a real likelihood that an adjudicator's decision might be overturned and the money will have to go back, but that company will be bust, the court will look to stay the decision, so you don't have to pay the funds across. Now, it's not necessarily always going to be the case. There are certain things that the court will look at. So, for example, if that company receiving party was in a distressed situation before you went into contract, then a court's is unlikely to turn around and stay it for that reason. They'll take the view that, well, you knew it was in a bad situation, you knew the risk at the outset, you can't now start complaining about it. Likewise, if, for example, the reason that this company is struggling is because you've not paid across money that you should have paid, you can't really use your own refusal to pay money and therefore making the company distressed as a reason not to pay them the money they're entitled to. But there are options. It's certainly worth looking at. It often involves a degree of understanding of both the insolvency process and the Construction Act. So it's often useful to have sort of insolvency expertise tied into construction expertise. But the options are there to look at. Obviously, as an aside from that, as Matthew mentioned previously, if you do have to pay money across because you've lost a smash and grab decision, you can start a true value adjudication. What we would say though is that you need to make sure that if you are potentially at risk of losing a smash and grab claim, you take as many positive steps as you can do to get that true value adjudication ready to go. You can't start the true value adjudication until the money's been paid across. But what you don't want to do is to lose the smash and grab adjudication, have to pay the money across, you start your true value adjudication, 4 or 5 months later, at which point in time it might be too late. So if there's that risk of losing a smash and grab, we'd always say try and take positive steps so you can hopefully be in a position where day 1 you pay the money across, and then day 2 you're starting your true value adjudication.
So we've obviously talked a lot about the risk of being a victim of a smash and grab. Of course, on the other side of the fence, if you're a contractor and you don't feel that you're being fairly treated in terms of the certification of your account, obviously smash and grab is a great weapon that you can use. And obviously we do also act for contractors bringing claims on their behalf using the option of smash and grab. So really everything we've sort of said so far today, the mirror image of that, you've got to think about that from a contracting perspective, is that make sure your applications are on time, you do follow the contract, and then if the employer doesn't serve a notice on time, then if it's appropriate, in your commercial relationships do that, then you do have the option of a quick, easy kill to get paid, rather than having to go through a much more complicated and expensive adjudication proving actual entitlement. And once you've got the cash in, it puts you in a very strong negotiating position. I think, Will, you've also done quite a few of these on behalf of contractors recently, haven't you?
Yeah, well, I think we all have, really, if I'm honest. It's like you said, it's part of your arsenal. It's an option that's out there. The Construction Act makes it clear that payments are on an interim basis certainly are all about cash flow, making sure money is flowing around the chain, making sure people are getting paid. Once you've got your money in, as you say, you're in a much stronger position. So I think it's one of the many facets that might be available to you. It's all part of a potential strategy that you can use to try and make sure you're in the best possible situation.
Okay, so let's do our third question now. How do you protect against downstream insolvency? So putting smash and grab to one side, even if you've not fallen foul of that, it's still potentially a major problem for you if somebody below you in the chain does go bust. If there's lots of defective works, the cost of which to put right exceeds the value of your retention, then you're going to have a serious issue if you're a main contractor and one of your subcontractors goes bust, or if you're the employer and your main contractor goes bust. If you're the employer, you're also potentially going to have an issue in terms of getting the project finished, where there might be specialist subcontractors that you'll need to engage with directly once the main contractor has fallen out of the loop, and you'll need to get them on board and their specialist knowledge and their warranties that you'll need as well to get the project properly finished off. So going back to the pre-contract stage, is there anything you can do, Abby, at that point to protect yourself against a future insolvency once the project's running?
Yes, I mean, absolutely. There are various options you could look to put in place to try and strengthen your position in that scenario. You could ask for a parent company guarantee, and the parent company then is on the hook for any sums which the subsidiary doesn't pay. So if, for example, the subsidiary is liquidated, you're then entitled to get your money back from the parent company. The good thing about a guarantee is that normally you don't have to claim against the subsidiary first, which then potentially saves you time and money that you would have to spend otherwise. But a really crucial point to check is that the parent company actually has sufficient assets to cover the subsidiary's performance. Otherwise, it's just not worth the paper it's written on. They can be drafted to be what's known as on demand. And by that, we mean that only a compliant written demand needs to be made to make a claim under it, as opposed to otherwise having to prove any particular breach of contract by the company, which is hugely beneficial if you're the party making a claim under it. If you are benefiting from the guarantee, a key point to check is that it can actually be called on if the subsidiary becomes insolvent. A general ability to claim under the guarantee for any breach of contract won't necessarily cover insolvency unless insolvency itself is specifically a breach in the contract that you're operating under. And for example, in the JCT 2016 design and build contract, the employer can terminate for insolvency, but it's not an express breach of contract under those terms. if you're the one being asked to give that parent company guarantee, make sure you understand the implications of it. They are, by their nature, fairly onerous documents, and they're normally irrevocable and can be unlimited in time-wise and amount there. Ultimately, with guarantees, their value lies in the detail of the drafting and a good understanding as to when and how they can actually be called on.
So you mentioned there, Abby, obviously the issue of guarantees are only as good as the company that stands behind them. So when when an employer is looking at tenders and deciding, who to select, I suppose the question for you, Steve, really is, what can you do to spot companies that might be at risk of going bust at some point soon?
Yeah, absolutely. Prevention better than cure, being the idea. There are lots of things you can look at, and gathering intelligence about somebody you're about to leap into a significant contract with is always a good idea. And we used to call it educated guesswork, but it's a bit more sophisticated than that these days. There are lots of good tools out there available for people to use. Certainly, before entering into the contract, I would recommend doing a credit check. It's a very obvious point, but if the company that you're about to enter into a contract with is not making payments elsewhere, might have CCJs, for example, they're obviously having problems, so maybe you should think twice. Similarly, there is information freely available at Companies House. You can check historic accounts, you can check appointments, and various other information on there. Particularly, you're looking to see whether or not a company has a long and stable history, in which case you might feel a little bit more relaxed about the process. But if it's a new entity, then, and particularly if it doesn't seem to have much in the way of the financial assets behind it, you might think it's one that the owners would have no problem dissolving if they have issues or run into problems in the contract. There are a number of other practical red flags you might also look for. I would say that maybe anyone on their own might not necessarily be cause for huge concern, but there's a cumulative effect. So if there are more than one, then you start to get a picture of a company in distress. So things you can do are certainly have a look online, a simple Google search, see if there's any adverse publicity, any hints that there are issues out there. Virtually everything seems to be captured online these days, so you may well find that there's information at the click of a button. I would also pay mind to a high turnover of staff. If people are leaving and moving on, and particularly or aren't staying long, this might be an indication that it's apparent to people within the business that there are problems there and maybe the company is failing. Similarly, relaunching and rebranding, that can sometimes be an indication that things haven't been great up to press, and it's a new attempt to breathe life in something which is having issues. And I think, come back to that word again, intelligence, general market intelligence. If this is a brand new player in the market, they've got inexperience in this area of work. Without that track record behind them, why would you risk getting into bed with them? So that's something to bear in mind as well. All of those are very sensible steps to take prior to entering into the contract, but don't discount ongoing monitoring and checking these things during the contract, because you can, if you feel that there's a danger now posed by the party that you're now in a contract with, you may very well be able to take or make use of the contractual provisions and assistance, the likes of which Abigail's already described, and I'm sure that there are others out there, Abigail. Yeah,
I mean, in terms of other forms of security that you can look at putting in place, performance bonds are another really useful option to look at. That's a guarantee by a bond provider, which is normally a bank that people tend to use for the contractors or subcontractors' performance of the contract. The bond provider normally promises to pay a sum of money when they're called on, and usually that's limited to around 10% of the build cost. They are normally time limited as well and tend to expire on practical completion. The beneficiary's ability to then call on the bond will again depend on how it's been drafted. As with parent company guarantees, really, if you're the beneficiary, you want to get a bond in place that's drafted to be on demand, where you've only got to make that compliant written demand to be in order to access the money. But it's important that, as with guarantees, you check that it doesn't exclude a right to make a claim in the event of insolvency. The downside of a bond is, like I've said, it is only usually for around 10% of the build cost, and it's essentially intended to fund finding a replacement contractor. Also, any bank or whoever the bond provider is likely to charge a hefty fee and potentially insist on taking a charge over the contractor's assets. They may also want to say in the triggers for getting access to that bond money. So those factors can create some potential obstacles for putting one in place and setting that bond up. Whilst these further options are not used as often, there are some alternative types of protection that you can put in place, such as a project bank account or escrow account. If there is no parent company and that 10% bond isn't going to cut it to provide you with enough security, or you might be dealing with a foreign or high risk contractor or a complicated high value project, or maybe all of the above, those accounts can be good options to put in place. Both project bank accounts and escrow accounts involve monies being paid into a safe place and being drawn down on as the project continues, but they are fairly complex documents, and if you do want to know any more about them, please let me know.
Thanks, Abby. So I think we're now ready for our fourth question. So what happens and what can you do if your contractor goes bust during the project, which I think Will's going to look at first of all?
Yeah, I think there's probably two things to say to start off with. The first thing to remember is that a company becoming insolvent doesn't automatically bring the contract to an end. So just because a contractor or a subcontract, for example, has entered some form of insolvency process doesn't mean that the contract is now over. The parties' obligations remain unchanged, usually, unless there's some kind of automatic trigger in the contract, which there isn't normally. Second thing to remember is that insolvency is a bit of a broad church, and there's not all insolvencies are equal, I suppose, is one way of putting it. So, for example, in the JCT, the serving of a winding up petition is a form of insolvency. However, a company entering into a CVA isn't. So what you need to make sure you're doing is that when it comes to your contracts, your definition of insolvency is drafted as widely as possible. Steve is the expert. He'll probably have to tell you, 9 or 10 different forms of insolvency that I won't even think of, but you need to make sure they're all catered for and covered in your contract. And now, presuming you have got your contract drafted, so insolvencies are quite widely defined, it's then a case of working out what to do when your contractor goes bust. Now, it might well be that, for example, you want to draw a line in the sand and you want to bring the contract to an end. Obviously, that's absolutely fine. But what I would stress is that on that insolvency issue, and the step you take to terminate the contract, you need to make sure that you're complying with the contract and following the various notice provisions that might exist. If you don't, as I've said before, the contract effectively remains in existence, and you can find yourself in a situation whereby you've got a claim coming at you for breach of contract because effectively you've not complied with the contract because you think it's over when it isn't. So it's really important that you dust off your contract and you make sure you fully comply with any steps that are needed.
I suppose, Abby, one of the big problems that an employer might have when the main contractor goes bust is that you've obviously got specialist subcontractors and suppliers and specialist consultants that you then need to engage with directly to get the project completed. What do people need to think about in that regard?
Yeah, so at the outset, when you're entering into the contract, I always advise clients to make sure that your main contract obliges the contractor to procure collateral warranties from any specialist consultants and any specialist subcontractors that you might have, to ensure that you've got that direct contractual link in place with them. You, if you're worried about actually making sure that the contractor is going to do this because there may be a number of those particular consultants and subcontractors that you want to have that link with, then you can amend your contract to allow you to withhold payment until those have been provided. When you do that and go to draft your contract, make sure that you specify the exact form of warranty that you want them to take, in order to ensure that you've included what's known as step-in rights. These step-in rights then allow you to step into the contractor's shoes and complete the project if your contractor becomes insolvent before the works have been completed. Whoever the beneficiary then is of those step-in rights then effectively becomes the paying party, pays any sums due to the consultant or subcontractor, and is able to then see the project through to completion. They are extremely useful in order to be able to see a project through to the end in circumstances where contractors become insolvent. Might not be particularly helpful, and otherwise it might be quite difficult to try and track down all those specialist subcontractors and consultants, which could be crucial to you getting the job finished. One important thing to note again when it comes to insolvency is make sure that those step-in rights that you've got in the relevant document do contain a contractual right to step in, specifically if the main contractor becomes insolvent.
That's great. So I think that brings us on to our final question. How do you protect yourself against upstream insolvencies? So far, we've really been looking at mainly downstream issues, but in a bad recession, you potentially have the problem of employers going bust as well. That's particularly a risk in high-risk projects in the commercial and the retail sectors. And if you're a main contractor and you've done a lot of work for a client, and then they go bust before paying your latest valuation, it could be potentially catastrophic in terms of the financial hit that you would take in that scenario. So we've already looked at checking out the financial position of companies when you're looking downstream, and I think those considerations apply equally upstream. But when you're talking about the main contractor's position and when he's looking at what company is going to do business with, are there any particular things, Abby, that you need to be looking out for?
Yeah, definitely. I would say be aware of developers potentially setting up special purpose vehicles for the project that you're going to be working on. Those are really beneficial for them because it limits their liability to the limited company that they've set up. But for that reason, it's likely to be a shell company with little or no assets at all, which then potentially leaves you exposed if you then need to make a claim. If you don't really know who you are going to be dealing with, find out who owns the property you will be doing the building work on. You can do this via a land registry search, and then you could consider contacting the property owner to try and find out a bit more information. If you are worried about the employer's status, think about putting in place some of the security documents that I've talked about to try and protect your position. Parent company guarantees, project bank accounts and escrow accounts can all be used to help with this and can be really useful. Also, have a think about how retention is going to be held by the employer. On large projects, this could potentially be a very significant sum which you don't want to lose out on receiving at the end of a project. A way of protecting it would be potentially to hold it on trust by the employer in a separate bank account, and then that ensures that if the payer does become insolvent before the job's completed, that retention is then protected rather than being swept up by the payers. Some of the standard forms do have this in them, but normally it only operates as an option if the parties have specifically selected it to operate in their contract.
So I think another thing that main contractors can look at is putting a pay when paid clause for insolvency into their subcontracts. So this is a clause that provides that where the main contractor's client goes bust and doesn't pay the main contractor, then the main contractor doesn't have to pay his subcontractors. So effectively the sort of risk of insolvency is passed down the chain. However, if you're thinking of using one of these clauses, it's absolutely essential you get it drafted correctly, because if there's any defect in it, it won't be enforceable. And as this slide here reminds us of, we had a case back in 2010 which went all the way to the Court of Appeal, where exactly that scenario came up. So obviously this is the last time we had a really bad recession, and as I said, the risk in that type of recession is that a development goes under. That's what happened here. It was the Trinity Walk development in Wakefield, where the property owner went bust. They didn't pay Shepherd Construction, who were the main contractor, because they'd gone bust. And then Shepherd tried to avoid paying my client, CR Reynolds. They tried to rely on a pay when paid clause. Fortunately, however, from my client's perspective, their contract was not up to date. The form of insolvency which happened here wasn't actually identified in the pay when paid clause, because it had been drafted probably before the Insolvency Act had been amended to bring in new ways of going into insolvency. Shepherd still tried to rely on it. Their argument was, well, you know what we meant. Clearly we meant any kind of insolvency, but the court wasn't having any of that and decided against them. And they were therefore forced to release the cash to my client and also the various other subcontractors. So if you want to try and rely on one of these clauses, you've really got to make sure that you get them right and keep them updated. And I think, Abby, you're going to say a few words just about how you can ensure that they are done properly.
Yeah, as you said, Matthew, the pay when paid on insolvency clauses can be a very helpful tool to avoid paying your subcontractors when you've not been paid by the employer, so you just simply don't have the cash. But they need to be carefully drafted into your contract to make sure that they're actually effective on an insolvency. It's not as simple as inserting some wording and hoping it'll do the trick. They need to explicitly refer to only giving the contractor the right to withhold payment if the employer becomes insolvent and doesn't pay the contractor. A contractor can't just sit on the money, rely on the employer being insolvent, notwithstanding the fact it has received payment as a reason to then not pay a subcontractor. The terms also need to be properly incorporated into your contract to be effective, making sure that they don't inadvertently contradict existing terms that you've got in place already. So this is really a classic example of something that I would highly recommend getting legal advice when drafting it, to make sure that you have that proper protection in place.
And I think if on the other side of the fence, if you're a subcontractor and you've been sent a draft contract, you need to avoid these clauses. They're very draconian from your perspective. So if someone tries to put that into the contract, I'd definitely recommend striking it out and resisting that, particularly if we're going to go into a potentially more difficult trading environment. So I think the very last point we've got to consider on this topic is, in that situation where the employer does go bust, can the main contractor just walk off site? And I think there's some new insolvency law, Steve, which you're going to talk about, which potentially makes that a lot more tricky now for a main contractor in that scenario.
Yeah, it does. I'm conscious of time, so I'll be a little bit brief with this. But lots of the new legislation that's been brought in temporary measures, but some of it has brought in some permanent changes to how insolvencies are treated, and also the impact of insolvency on certain contracts. In particular, a nasty new provision has been put into the Insolvency Act 1986, which affects termination of contracts upstream for reasons of insolvency. It's actually now prevented, and the provisions in the new provisions in the Act also prevent upstream contractual termination for any other reason where that right to terminate hasn't been exercised before the insolvency has occurred. It goes even further, actually, and says that any other thing due to insolvency can't be exercised either. So it's a deliberately wide concept. It will prevent exercise of a retention of title clause due to insolvency, or arguably even guarantee provisions if they're in the main contract rather than a separate guarantee. So it's quite a big deal. It's quite a big change. And the net effect of it is that, depending on the circumstances, the supplier almost has to continue supplying the insolvent company, even if payment hasn't been made for goods and services that have already been delivered. Fortunately, the Act does bring in some ways that you can terminate it, and it basically creates exceptions to that scenario. I won't go through them all. Probably the two that are most relevant are that if the continuation of the contract will cause the supplier hardship, which might be, for example, the possible insolvency of the supplier itself, then the contract can be terminated in those circumstances. But it does require an application to the court and a court order, so there's extra hurdles and barriers there. And the other one, which is definitely worth mentioning, is that it's still open to the contractor to terminate if an appointed insolvency practitioner refuses to provide a personal guarantee for payment of further supplies to be made during the insolvency. That's quite a powerful tool. I deal with insolvency practitioners every day, and I can promise you all that very few of them will agree to provide a personal guarantee. So if you want to be out of the contract, just ask them for one.
That's brilliant. Thanks, Steve. So that's the end of the sort of the topics we wanted to talk about. So I think we've had some questions, Tom, before which I'm going to read out. Yeah,
we've had a couple of questions. It's been fascinating. It's been absolutely fascinating. I've been tweeting like mad. So this is the first question. How do you deal with payment terms where they require you to make an application for payment before raising an invoice?
Yeah, I think that's probably one for me, and that is a good question, and it's a difficult one, because until you've gone through your payment process under the contract and you've made your application for payment, there's been the opportunity for the payer to put a payment notice in, and then potentially they might want to put in a pay less notice. You're not going to know how much you'll be paid, and therefore how much you can actually invoice for. So the reality of it is that obligation for you to provide an invoice needs to come after all of those deadlines have passed. Otherwise, I understand from an accounting perspective, it's going to then be very difficult to reissue another VAT invoice. So I hope that answers the question and what you were driving at there.
Yes, I'm guessing it does. What are the current cash flow options for contractors to help manage risks?
Oh, I'll take that short, I suppose. I mean, there is an inherent problem, I suppose, in the way construction contracts work, is that if you carry out work, say, at the beginning of May, you're probably not going to get paid for that work for 2 months. It's unfortunate. It's just the way that construction works, and it's probably one of the reasons why traditionally it's an industry which can take a bit of a battering in terms of cash flow. I mean, there's no right or wrong answer to this, but there's various things you can do in terms of helping cash flow. So often traditionally people will have assessment dates at the end of the month and then payment at the end of the next month. So effectively you've got that sort of 60 days. There's no reason why you can't shorten that. You could have due dates once every 14 days or payment terms that are on 14 days, which will help with cash flow. It's more administration, but we have seen it in the past whereby people have said, look, we'll give you a 5% discount or whatever in exchange for the shorter payment terms. So from the payer's point of view, they've got to pay for it anyway. They're actually getting a discount for it. And from the payee's point of view, whilst they're getting paid slightly less, it's helped from a cash flow perspective because they're getting paid more regularly. Other things you can look at are things like weighted stage payments, so you can get more money up front, which might help in terms of juggling where your cash is. It might have an effect towards the back end of the project in terms of cash flow, but I suppose you've got the money in and then you can manage it yourself. And you can also look at things like advance payments if you can. It's particularly relevant for situation where you might be buying products up front. If you can factor something into the contract whereby if you've got to procure materials up front, you can get paid for those separately up front, then that will help with cash flow. You're not effectively having to buy items and then waiting 60 days or whatever it is to get paid for them. So hopefully that answers that question.
That's great. We've just had also had a question on the chat that we'll just quickly try and answer from Fergus, who's asked, what protection would you recommend when having to make advance payments for off-site goods or when manufacturers require it before commencing design and fabrication? I'll try and answer that first. I think obviously we've said about making credit checks on companies. Clearly, if you're paying money out, you want to have some confidence that the person that you're paying the money to is going to be around, is not going to go bust. You could, if it's a large amount of money, I think, set up an escrow account. So you could pay the money into an escrow account so the manufacturer has the confidence that the money is separately held and is not going to go anywhere. But then you have the confidence that if the manufacturer doesn't deliver the goods, that you can then get the money out the escrow account again. I'm not sure if anybody else has any thoughts on that question, the rest of the team at all. Well, hopefully that's answered that question, Fergus, and thanks very, very much for that. So just conscious we've kind of gone past 11 o'clock now, so just want to say thanks very much for everybody attending. Thanks to Liz and Donna and Tom at Construction Excellence, and also my colleagues Steve and Emma at Gosschalks, who've helped us to put this together and organise all of this. Do you want to say anything, Steve Savage, from a finishing point of view in terms of anything at all?
No, it was really just to thank everybody for the time and thank the guys at Constructing Excellence for assisting with everything. As we said at the beginning, we will send out a contact sheet. So if anybody wants to get in contact with any of you individually, they've got your direct contact details. And also we'll put some of the some additional questions that we've received offline as well. We'll put them in a bit of a Q&A paper. So if anybody leaves the session today and reflects on some of the content and you then come up with some questions, it's not too late to get them in. Please do forward them either directly to us or to Liz and Donna at Constructing Excellence, and we'll see that we get them answered for you as well.
Excellent. Okay, right. Well, I think that's it then. So thanks again for everybody for coming along. I hope you've enjoyed it and found it informative, and fingers crossed maybe next time we might be able to do this in the real world again and get back to bacon sandwiches and early morning coffee and all the rest of it. So thanks a lot and take care, everybody.